Hello friend, welcome back to the world of IBC. जैसे हर रंग कुछ है वैसे IBC का भी रंग कुछ कहता है. So, and we all understand that become a professional in this particular field, we have to do effort. Our input has to be given, friend. And मेहनत का फल रोज नहीं मिलता है दोस्तों, लेकिन एक दिन मेहनत का फल जरूर मिलता है. ध्यान रखें. सो अगेन रिपीटिंग इट राइट, मेहनत का फल रोज नहीं मिलता है. हर रोज मेहनत करने से एक दिन फल जरूर मिलता है दोस्तों. सो फ्रेंड्स, keep on doing that hard work and probably one day you will be a good practicing law world of insolvency. So in our last lecture we have understood the process of section 9, section 7, where the financial creditors and the operational creditors were allowed to file an application at NCLT against the corporate debtor. And that is why it is very important to understand the further process, that once the application is filed and if the NCLT accepts that particular application, what will happen for the continuation of the CRP process. So here today we are going to cover the key provisions relating to the interim resolution process, a very important angle, and probably this particular period of the whole IBC code is a very crucial for the objective of the particular IBC. And yes, very important, this particular process will highlight the role of insolvency professionals. Okay, so the role of interim resolution professional starts with the appointment and the eligibility, which we have understood in a bit, yes. And then the application and disclosures, which we have understood in section 7 and 9. And then thereafter, the process of public announcement, communication, and so on will continue. So if you see, there's a whole lot of job by the IRB. It's not only really, just managing the or taking the company towards resolution liquidation, but in between that you have to do lot many work. So we'll discuss each of the areas, right, from the communication, the role of IRB within the first 30 days, and after the form, that means after from 30 to 180 days, then 180 to 270 days, and after 270 till the liquidation process, what can be the IRP. So let us start with the appointment part. Going to again basic part, as I said, that we'll be reviewing finish as time to time whenever the word reference comes in. As per section 527, the court says that resolution professional for the purpose of this particular part, that is for the CIRP process, means an insolvency professional appointed to conduct the CIRP process and includes an IRP. So there are two words. There are two words which are being highlighted here. One word is the IRP and the second word is the RP, right? Two words, IRP and the RP. Now, who is an IRP? The IRP is basically, as mentioned in the second point, it is as per section 15 of the code, the term of the IRP shall not exceed 30 days from the date of his appointment. So the day is appointed by the NCLT. From that date till the 30 days of the whole process, the person RP is known as the interim resolution process, right? Remember, so the person is probably the whole context. If you understand, the person is same, but then for the first 30 days he is the IRP, and then there after the 30 days he will become an RP. Now the question comes when you say, so is the person same? The IRP and the RP is same in terms of the noun factor. The person is same, but yes, in physical the person may differ, right? For example, if X is a person who is appointed by NCLT as IRP, then he may be the RP also, Mr. X, or Mr. Y may come as RP. Remember, so the possibility is there that there will be a person physical. But yes, in terms of law, the IRP and RP is one and the same thing, except for the difference in the time period. Of first 30 days IRP and thereafter is termed as RP. So as per section 319 states that insolvency professional means a person who is enrolled in section 206 of the code, which we have already. I is a member and registered with the board. The two words are resolution professional and insolvency professional. The term IRP. From where the appointment comes in. So section one of the code says that the adjudicatory authority, that is NCLT, shall appoint IRP within 14 days from the insolvency date, that is the date of the admission of the application by the NCLT. Now, what does this mean? Let me tell you. So today, as a financial creditor, operational creditor, file an application as per the request form 5 or form 6 and submit it to NCLT. Now, as per the law, it is said that within 14 NCLT will take a decision whether the case has to be admitted to the CRP process or not within 14 days. But it does not happen. It takes about a longer period of, let's say, 6 months, 9 months. Right? So within that 6 to 9 months, all the deliberations go on to the court. And the NCLT decides that yes, the case has to be admitted. Then, then it is that the IRP will be appointed as the order of NCLT. So law says within 14 days from the date we file our application, but that does not happen. It takes about 4 to 6 months, and it may go beyond that also. And once the order is made, probably from the practical purpose, we'll understand that from the date where the NCLT makes an order of admission of the application, from that date, the IRP is appointed. Remember, from that date, the IRP is appointed. Now, there is another practical problem which comes in. So the NCLT today is an order. Yet, yes, case has been admitted for CRP and the appointed. But yes, the IRP may not be aware that the NCLT is given the order, and probably it may take more time period before the order is communicated to the IRP. So if you see the practical terms, the date of order is very important because from that date the CRP commences. But then yes, practically if you see, the IRP will come into the picture when the order is communicated to the IRP. So there may be a time gap from the date of order or the date of communication to the IRP. So practically this what happens, but theoretically it is said that the NCLT has to appoint within 14 days from the date we file our application. Then section 16(2) comes in, where the appointment of IRP, where the application is filed by the financial creditor or the debtor, and it says that the under the application you have to mention the name of the IRP. And in case of the operational creditor, then we know that the operational creditor to give the name of the IRP at the time of the application or not. So suppose the operational creditor is not given the name of any IRP when the application was made, then it is left up to the adjudicating authority to make a reference to the board for the recommendation of an IP, act as an IRP. And the IBBI, based on the list, panel list, probably they'll propose a name to the NCLT that you can appoint this particular person, and thereafter that person is appointed by the NCLT, subject to all the conditions which are required to be met. Right? So this is the whole process of appointment of the IRP once the case is admitted. Right? So scenario, just trying to recap, is that once the case is admitted, the NCLT will appoint an IRP, and as per law, it has to be done within 14 days filing of the application. And if it is a section 9 application where the operation creditor is filed, no name is mentioned in the application, then the NCLT may refer to the IBBI to propose a name of the IRP. So as per law, the IBBI act within certain time frame. So the IBBI will do it because again, as per timelines are very important under the IBC code. So as we have discussed, the interim resolution professional will not exceed 30 days from the date of his appointment. And then the rules which comes into picture now, as per rule 9(1), it says that the application has to be given by the IRP, that is in form AA along with form 2 as a written communication by the IRP that yes, is willing to accept that particular asset. And then rule number 9(2) says about the eligibility certificate from regarding that he agrees, he gives the registration number and all that is not being submitted, disciplinary proceeding. Okay, so that is first part, that the appointment of the IRP has been done. Now what next? What next will happen? And so in the NCLT order, as 13, the NCLT will give directions to the IRP and give their instructions that it is a public announcement has to be made, and the adjudicating authority shall declare a moratorium according to section 14, which is a very important element of this IBC code, and which forms again a base for the IBC code. Then they will instruct that you have to give a public announcement of the initiation of the CRP with respect to the CD to be made, and calls for claims in the matter laid down in section 15. And then the NCLT has appointed an IRP. So these are the three things which the NCLT will mention in their order. declare a moratorium, cause a public announcement, and then appoint an IRP. Right. So these are the three things which has to be done until the order. And what will happen once the order is made? The first thing, the first thing which the IRP will do is to make a public announcement, and that as per law has to be made within days from the date of his appointment. So once his appointment is done, he will make a public announcement in the papers. Normally, the public announcement will be done where the registered office of the company is situated, and in a in an English paper, and a second would be the local vernacular paper. And the public announcement will be done in Form A designated, where to give the basic details of the corporate debtor, the name of the authority which would be corporate debtor is incorporated or registered, basically the CIN number of the company, and then you have to mention where the last date for the submission of claims from all the creditors, financial and operational, and of the interim resolution professional who shall be vested with the management of the corporate debtor and be responsible for receiving all the claims, his mail ID, his physical address, and various other details. And then as the standard clause of penalty for giving false or misleading claims. So this is basically the important content of the Form A, which is nothing but a public announcement, which is made in the paper form. And that has to be done within 3 days from the appointment of the IRP. It will also mention, the date on which the CRP will commence, along with the date on which we will close, that is the 180. And I think it has to follow all the guidelines, which is as per the regulation 6 of the IBBI CRP regulation. So I think I have covered this. And yes, one more important point: the expenses of the public announcement shall be borne by the applicant. Now, what does this mean? Person who has made the application under Section 7 or Section 9, the cost of this public announcement will be borne by that particular applicant. Now, after the appointment and the public announcement has been done, normally the IRP, though it is not given in the rules, but then specially given in the rules, giving directions. But yes, that is the IRP, that he will inform all the bankers of the corporate debtor. If it is listed, it will inform the stock exchange, the ROC, then the depository of securities, and any other agency stakeholder involved in the whole process. The job of the IRP is to inform them that this company is now under insolvency process. So if any further information is you have to submit, or if you want to claim something, you can accordingly put in your claim or give the information. Now let us start. Now, once the public announcement, what will the IRP do? Obviously, there will be the first part will be where the IRP will approach the corporate debtor, the management of the corporate debtor, to the assets. That is the first part. That is the first angle where he has to approach the CD and take over the management and the operations of the company if it is running, right? And in part where he'll start receiving the claims from different stakeholders. So the claims will be received from the financial traders as well as the operational traders. And for that, all designated forms are there. So let's say there's a form C for the financial part, there's a form CA, B, form D. There are various forms. In that form, the particular class of the particular traders will submit their claims, and they will give all the details regarding the proof of their claim, along with the necessary documents and the affidavit and the disclaimer. So as per Section 3.6 of the code, claiming a right to payment, whether or not such right is reduced to judgment, if disputed, undisputed, legal, equitable, secured or unsecured. So irrespective of anything, if there was a right to payment, he can. Then right to remedy for a breach of contract and under any law for the timing in force. And if such breach gives a right to the payment, whether or not such right is reduced by to judgment, fixed, matured, unmatured, disputed, undisputed, secured, unsecured. So if there's a right to remedy for the breach of contract and party is liable or subject to receive the payment, then also he can claim that amount. So the claims can be submitted as per Section 5.7. A financial trader may submit a claim. The 5.2 Section 5 subsection 2, an operational trader can submit a claim. And then under Section 3 subsection 36, a workman also can file a claim. So there are different categories. Now the question comes: who is an operational trader, which is mentioned that whom an operational debt is owed. So if given an example, it's the person who supplies material, services. It can be an individual partnership from company or any other person. Even the government. And the government is classified under operational creditor, remember. So they have to file a claim as per the law. So financial creditor, some basic things which you have to remember. Financial creditor has to submit their claim only by electronic means. Remember, uh, they cannot submit it physically. That is important. Then, along with the claim, they have to submit a basis of proof of claim, all the records available with the information utility. Remember, we had discussed this point, the information utility. So if any, they have to submit it. And then all the other relevant documents, including the financial contract, the record evidencing the amounts committed by the financial creditor, and financial statement and order of court or tribunal that has executed upon the non-payment of a debt. So a lot many things will come into picture. Yes, what will happen? Let's say if I've submitted my claim as a financial creditor or the operational creditor, what will happen? So as per regulation 2, the CRP regulation says that a creditor who has failed to submit proof of claim within the time stipulated in the public announcement may submit such proof to the IRP or the resolution professional as the case may be till the approval of a resolution plan. That means here there's a flexibility which is given to all the creditors. Yes, that if you have submitted a claim, fine, then the next process will happen. Suppose you have not been able to submit the claim for whatever reason, then the time period is extended to that extent that until a resolution plan is being approved, till that particular time, I think every creditor can submit a claim. And what will happen if I submit it late? So there's no such problem. Only thing submission of claims is very important, but remember the timelines that as per the public announcement, the timeline is given, or if not, you are not submitted, maybe in extended time period, we can submit it. So this is regarding the claim part, friends, and from the financial creditor. And regarding the operation, we all know who is an operational creditor. So it may include the provision of good person who has supplied goods and services, including the employment. Remember, the employee also can file under as an operational creditor and also an government authority. And they have to submit their claim in Form B, as I discussed it, the Form C, the Form B. Along, we have to submit the various other documents that are necessary. And claims by employees. So for that, they have the Form D. So there are three forms: Form B, Form C, Form D. This is basically for the labor for working in the factory. They can submit their claim, and if there are more than X number of employees, then they claim to their authorized representative. Because in a company, there are so many employees, so they can do that to an authorized representative. So again, along with that, we have to submit the basis of the proof of claim for providing support, the evidence which is required as per the law. So 3 claims. Now we have understood that they can file their claims as per the deadline. So here we to the one part that is the claim part. As I said, there are 2 parts. The first part is where the IRP will take the management of the company, that we have to discuss. And the second part is regarding the claim part, where we have understood that the claims have to be submitted depending on the type of creditor, and there are various forms and has to be submitted within a particular time period. But yes, if you are not able to submit within the time period as mentioned in the public announcement, then you can submit it after that also. But then the last time period is the resolution plan is accepted. Okay, so that is all about the claim part. In our next lecture, now we are going to cover, in the next lecture, we are going to cover the role of the IRP in terms of the management of asset. Right? So thank you. See you in the next.